Hello, this is Pastor Mike in Southern Oregon. This is another episode of Investment and Truth Review. Today's subject is going to be sanctuary counties. It will be done under 2020. That's just the year V for video 005. Today's date is March 7th, 2020. Okay, I'm going to begin by reading the disclaimer. Yeah, let me get that done and get it out of the way. This is the new disclaimer that I wrote. I did make a little change in it, and I will reprint the disclaimer with the change on it. The information provided herein is for educational, truth, and knowledge purposes only. No specific course of action is directed except the advancement of knowledge and truth. When I say no specific course of action is directed, we're not telling you to do any particular thing. We're just sharing information with you for truth and educational purposes and knowledge purposes. The following understanding, opinion, and analysis is based upon the legal and related issues in the United States of America. For those who live outside the USA, you should consult the laws in your own country or consult with legal counsel. For those within the USA, if you conclude that my understanding, opinions, and analysis of the legal and related issues to be unacceptable or incorrect, you should do your own legal research, read the cases yourself, come to your own understanding and conclusions, or consult with legal counsel of your choice. As always, I, Pastor Mike Benjamins Jr., hereinafter will be referred to as Pastor Mike, address various issues as a pastor of God in my ecclesiastical office and capacity, primarily but not exclusively to keep believers in God as well as others aware of their various rights, freedom, and liberty under God or man and relative to their relationship with the various laws of man. No specific course of action is directed or implied, and the believer or non-believer should rely upon their own understanding, judgment, and conclusions upon which to base any acts or omissions for which they are solely responsible and are undertaken at their own risk, peril, and liability. Pastor Mike disclaims all liability and responsibility for the implementation of the understanding, opinions, and analyses set forth herein. The Remnant Church in Southern Oregon, as well as Pastor Mike, in both his personal and ecclesiastical capacities, including his subordinates and personnel, individually and jointly, disclaim any and all liability and responsibility for any damages sustained or suffered by the readers, viewers, or other entities in the implementation of the teaching set forth in this video or treatise. I reiterate, the material is provided as a research study project for learning purposes only, and any implementations or applications are undertaken at the sole risk and peril of such readers, viewers, or entities. No statement is made or implied as to the ultimate outcome resulting from such implementation or applications. Therefore, I hereby declare, claim, and assert on behalf of the Remnant Church, its pastors and personnel, individually and jointly, any and all legal and religious protections of whatsoever nature and kind, including protection from discrimination on the basis of religion, available under the inherent, inalienable, primary, and subordinate rights and laws. Okay, that's the disclaimer. I'm going to talk for a minute about the fact that I happen to be wearing a sidearm today, and you may notice that during the video. Now, I want to clarify, I don't always wear a sidearm. I do wear a sidearm sometimes when I believe I need to. When you see me wearing a sidearm, it's sort of a statement about our right, our inherent and inalienable right to keep and bear arms and to protect ourselves and protect our right to life. By no means is the fact that I wear a sidearm to be construed as me calling for armed resistance or a call to arms. I'm simply making the statement that we as inhabitants upon this planet have a right to protect ourselves, and we have an inherent and inalienable right to keep and bear arms. So I thought that I would mention that. Now, let's move on to the subject matter at hand. I've got an article here. It comes from the 10th Amendment Center, and it reads this way: most recent gun rights sanctuary counties are anything but. This is the article here. I'm going to refer to it later, but not right now. I just want you to know that some of this is based upon this article, where they go into various sanctuary counties, and we will be addressing not only the Second Amendment preservation ordinances that some of these counties and municipalities pass, but also what has been in the news here lately also is the immigration sanctuaries, and we'll address some of that as well. All right, now I wrote a treatise. This is the 3-part treatise. I have it right here. It is about, let's see what I entitled it. I said Part 1, the attempts in Oregon and other states to create Second Amendment sanctuary counties and cities. This was issued under Code 2018A, which means that it was done in 2018, under Code number 0106, 0107, and 0108, because it's 3 parts. I actually assigned a different code number to each part, which I don't do anymore. What I've done after that was I would just sign the same code number but have 3 parts to it. All right, let's get into the sanctuary county issue, and municipalities, by the way. In this article that appeared in the Oregonians against the assault weapons ban, a site entitled, this is that same article I just referred to, most recent gun rights sanctuary counties are anything but. Permission not required post, which apparently originates from the 10th Amendment Center. I read the entire article, and in response thereto, I wrote the following commentary, which I now share with you. All right, greetings. This is Pastor Mike. I wrote. I looked at the entire 10th Amendment Center article, and I just want to make a few comments and observations about the local, county, and city ordinances, which would, at least on paper, strive to create Second Amendment sanctuary counties and cities. We know that the case of McDonald versus Chicago, I've talked about this in the past, came in 2010, 561 U.S. 742, made the Second Amendment applicable to the states by a process of selective incremental incorporation of the Bill of Rights upon the states. So be aware of that the Second Amendment wasn't even applicable to the states until 2010, which means that from 1791 to 2010, the Second Amendment was not applicable to the states. All right, let's go on then, and I lost my place here for a minute, but I'll find it again. But neither the 9th or 10th Amendments have been incorporated upon the states, and it appears they never will be. That is the consensus among many in the legal community. So we cannot legally use the 9th or 10th Amendments as incorporated at the state level. Now, if you're not familiar with this incorporation doctrine, I wrote another treatise about that, about selective incorporation of the Bill of Rights upon the states. You need to become familiar with that doctrine. It's important. How was the Federal Bill of Rights made applicable to the states? And it's important. Now, the 9th and 10th Amendments have not been incorporated upon the states, as I just said.
Where can that be found?
Okay, that I'll get to that later. You know, I wrote treatises on that, and I also mentioned it in videos. So, even so, those 2 amendments do give us keen insight as to state rights and individual and collective rights of the people relative to the federal government. All right. Moreover, we know that there is federal sovereignty and state sovereignty. No problem there. Now, if you're not clear on that, the sovereignty issue and the jurisdiction issue is extremely important to all this that we're going to talk about. So I'm going to take a minute now to stop reading and just talk about that sovereignty issue for a minute. Sovereignty starts with the people. That's where it begins. The case on that is Chisholm versus Georgia. I've spoken about that in other videos and in writings. Chisholm versus Georgia, written by John Jay, Justice John Jay. He explains that the sovereignty devolved onto the people, and they are the sovereigns of the country. If you didn't know that, you need to know that. The sovereignty begins with the people. Then government was instituted among sovereign people, and then you get state government. Okay? When the state government is established, it too holds sovereignty. And that sovereignty doesn't come out of thin air. It is sovereignty endowed to the state by the people. It is not a separate sovereignty that they can just grab onto and say, we're just now sovereign. It doesn't work like that. And the reason it doesn't work like that, there are reasons. Not only is government instituted among people, and people create the government, but all people are created upon equal terms. All people, if you're not a believer, I say created because I'm a pastor and I believe that our inherent and inalienable rights come from God. He created us. If you don't believe that, if you're an unbeliever, then you can go a different route and say, well, those are our natural human rights. And we have those rights by way of just being born as a human upon earth. Either way, we all hold the same rights. We are all equally endowed with the same rights and protections. Therefore, no person has more rights than any other person. Now, if a group of people could then be being created equal or born equal, could then get together and say, we're going to form a group called government and we're going to endow to ourselves more rights than the rest of you out there who aren't in the government. And then we're going to dictate to you what your rights are going to be, even though we have no more rights than you do. You see the problem there? You see how that can get out of hand? Government does not spring up on its own by just some people got together and say, let's just create a government, and when we do, we're going to impose that on everybody else because government will become more powerful than the people. Now we're going to use oppressive means to force them to do or not do what we say. That's a problem. So be aware. If you back engineer sovereignty, you start with, I start with God. God endowed us with the people with sovereignty, and then government endowed the people endowed the government with sovereignty, and then we'll move on from there. So there's how state sovereignty comes into being. That's where state sovereignty comes from. Then the states and the people got together and created the federal government through the U.S. Constitution. That's how that works. They did not pop up all on their own. Just some people that are equally endowed to the rest of us just popped up and say, hey, let's just call ourselves the federal government. And then we're going to say now we have power over the people and the states because we're just going to seize sovereignty and say that we're more powerful. And then let's go ahead and write a supremacy clause stating that we're the most powerful. Let's do that. And then every time somebody questions it, we'll say, well, did you read the supremacy clause? We're the supreme power. You see, you got to understand how all this stuff works. Where did the federal government get its sovereignty from? Well, it got it from the sovereignty of the people. And the states. The states are the ones that agreed to create a federal government. And in this particular case, in the United States, it's a union of states. So therefore, when I talk about state and federal sovereignty, you need to understand where that comes from. Let me make another statement here. I'll do it right now so that you know, so that you get a feeling for how all of this has to work. Only sovereignty trumps sovereignty. Now, I said this in other treatises and I've said it in other videos, but remember, only sovereignty trumps sovereignty. If you forget that rule, you'll get lost in what's going on all around you in the government and in the media and talking to other people, and pretty soon it's a mess. Nobody knows how it really works. All right. Therefore, we're dealing with sovereignty, and when you're dealing with sovereignty, you're also going to be dealing with jurisdiction. Now, let me continue. But neither counties nor cities, municipalities, enjoy sovereign status. Correct. That's important. Are counties sovereign? The answer is no. Are municipalities, which we call cities, are they sovereign? The answer is no. Can county sovereignty, can a county that is not sovereign trump something that is? The answer is no. Can a municipality which is not sovereign trump the sovereignty of something that is sovereign? The answer again is no. Okay, remember that. The reason why the Bill of Rights didn't apply to the states originally, this was confirmed in Barron versus Baltimore in 1833, 32 U.S. 7 Peter 243 was a case cite, was precisely because the states were sovereign and they were to handle various issues of law at the state level that were not given to the federal government to handle. Now let's talk about that for a minute. The people in the states created the federal government, but they didn't just say, let's create an all-powerful, all-supreme federal government. Let's do that. They didn't do that. The Constitution of the United States sets forth guidelines for what the powers of the federal government were to be. And the Bill of Rights itself was put into the Constitution to keep the federal government from extending too much authority over the states and the people, for that matter. So the Bill of Rights was a way to say, well, these are some of the things you are not to violate. The Second Amendment being one of the very clear amendments that says, shall not be infringed. The First Amendment, very clear, it says that the Congress shall make no law, and then it sets forth in what areas Congress shall make no law. When they go ahead and forget what the Constitution actually does, and start thinking that we're all-powerful and all-supreme, and when people say, let's say you're going to take an oath of office, and you swear to uphold the Constitution, and then promptly consider that just a formality to getting into office, and thereafter start violating the Constitution with all kinds of things that you do, forgetting that you're not supposed to do that, and that you're saying, well, we're the federal government, we're just going to use the supremacy clause to do whatever we want to do, constitutional or not. Well, that again, that is a problem. Again, they were not given the power to do that. All right, let's move on. Every time I leave the page, then I forget where I was. Okay. Then, after the 14th Amendment in 1868, the U.S. Supreme Court later created the doctrine of selective incorporation upon the states, beginning with the case of Chicago, Burlington, and Quincy Railroad versus City of Chicago. This was in 1897, 166 U.S. 226. Okay, so here's what happened. The Barron versus Baltimore case said that the Bill of Rights was not applicable to the states. Okay. Then in 1868, the 14th Amendment comes in, and it is possible, that doesn't mean it happened right away, it is possible to use the 14th Amendment Due Process Clause, for example, as an avenue or a conduit to apply the Bill of Rights onto the states. That didn't happen until 1897 with this case that I just cited for you. The important thing to remember here, when speaking about county and city ordinances which attempt to legally create Second Amendment sanctuaries, is that such government subdivisions within a state are subject to the laws of the state in which they exist. Thus, they have no sovereign authority to override state law. Okay, here is the very crux of the matter. Yes, can county commissioners get together and pass such an ordinance? Yes, they can do that. The question is, how much effect does it have? How much actual legal authority and weight does it have? That's what you have to ask yourself. And now you know that because the county is not sovereign, it cannot trump the sovereignty of the state. The same thing is true of municipalities and cities which would take that kind of an action, which of course in the immigration sanctuaries, they are trying to do exactly that. They're trying to trump the sovereignty of the either the federal government or the state, whichever the case may be. In this particular case, since it's immigration, it'd be the federal government. You see, they have to have sovereignty to trump sovereignty. Now, when I say that a county or a city does not hold sovereignty, it is in fact a subdivision of the sovereign state. A municipality is a municipal corporation, and a corporation is a creation of the state. They exist by the enabling statute or enabling act of the sovereign state. The same thing is true of counties. Now, there's no problem with a state saying we can have local county governments and we can have local city governments. No problem with that. That's just an administrative way of taking care of things locally. But what I want you to understand, so that you understand what's happening here, I have had many occasions over the years. I've been at this over 3 decades. I have had many occasions to read city ordinance and to read county ordinances. And I have yet to read any county or set of county ordinances or city ordinance that did not say somewhere that the city or the county adopts the statutes of the state. So therefore, that tells you that they are bringing in to their city ordinances or county ordinance the statutes and sovereign authority of the state is brought down to that level, because they are subdivisions within the sovereign state. So that tells you right away, if you pass a city ordinance which violates state law, you're against yourself, because you adopted state law into your set of ordinances. And you need to think about that, because that is a contradiction. You can't have it both ways. So think about that as we're going along talking about these sanctuary counties and cities. While I personally admire the effort and the gesture to create a place where the Second Amendment shall not be violated, as unconstitutional under both the Second Amendment and the Oregon Constitution, Article 1, Section 27, here in Oregon it would be that section, it has no legal weight or effect. And I just explained to you why that is. So yes, can you pass an ordinance like that? What legal weight or effect is it going to have? Okay. However, if enough counties and cities make the gesture, it does inform the state that strong opposition exists and that enforcement, depending on what law enforcement actually does or doesn't do, may impede the effort to disarm citizens within the state. ordinances in Oregon counties which to some degree favor Second Amendment views were either passed, considered, or balloted in Wheeler County, Wallowa County, Curry County, Columbia County, Klamath County, that's where we are here, Douglas County, Lynn County, Yamhill, and Baker counties. Obviously, that is a strong pro-gun rights showing which the state of Oregon should take careful notice of. So even though it doesn't have the legal weight or effect, it's still a gesture which tells them we don't agree. We don't agree. We're going to do what we can to resist what you're trying to do here. The wording in the Coos County Ordinance was particularly strong, as evidenced in the above-mentioned 10th Amendment Center article. We'll get into that later. Okay. I do agree that such county and city actions and statements can be successful in thwarting state efforts to impose legally unsound deprivation of rights upon the people. So too must an individual citizen demand his or her rights as a belligerent claimant of their rights in person. A belligerent claimant in person. This is something that comes from the wording that comes out of case precedent, by the way. I don't mean with violence. I mean a belligerent claimant in person means that you sternly and strongly assert your rights. That's what you should do. Judge Andrew Napolitano stated, when referring to local government non-cooperation with unsound federal and state laws, doing the same on gun control measures will make them nearly impossible to enforce. That's what Judge Napolitano says. He says if enough people don't cooperate, regardless of the fact that they don't have sovereignty to trump sovereignty, but if enough people don't cooperate, it might become difficult for the actual sovereign state to enforce such laws. Which is a good point. It doesn't change the legalities of it, though. Unity in opposition to unjust laws, which violate our basic rights, can be very effective in either stopping, slowing down, or making ineffective and hopefully preventing such laws. We can maybe send a message to the state and say, look, don't pass these unconstitutional laws. We're not going to cooperate. We don't like it. There are people who absolutely believe that if you're going to infringe their right to keep and bear arms, that their rights will follow, and I agree with that. I'm one of those people who believes exactly that. Okay? I hope my commentary will be of some benefit in helping people understand the whys and wherefores of the subject matter we've addressed here. Let's see what I wrote below that. Is this anything that I need to talk about? I'll go ahead and read it, see what I wrote. My friends, I tried to share the post itself to my timeline so that it could be seen. Okay, yeah, we don't need that. No, I think we don't need to address that. Okay, so I've said enough there. Do you have anything that you want to say about anything I've said about that first part? Okay. Let's go to part 2 of sanctuary counties. Let's see what I rattled on about here. In the commentary flowing from the Second Amendment sanctuary counties, this is just a repeat that it comes from the comes from that same source, you know, this article here that we're talking about. So we don't need to reread that. I respond as follows. Response 2. Until the 9th and 10th Amendments are actually incorporated onto the states, which of course, like I said, has not happened, is not likely to happen, I have actually spoken to attorneys who have told me that for a lot of attorneys, they don't even refer to the 9th and 10th Amendments. They refer mostly to Amendments 1 through 8. That's the ones they have the most to do with. I think that's a big mistake. I think that the 9th and 10th Amendments are supremely important. Okay, making them legally applicable to the states. We have no standard way to enforce those amendments until they are incorporated onto the states and made applicable on the state level, okay? However, the people can enforce the content, wording, and principles of law that are set forth in those amendments, and there is a difference. If the federal and state governments become compromised and then fail, to varying degrees, to uphold their oaths of office and laws that protect our basic rights, then the people become the last line of defense against such a state of affairs. In this, unity is key to creating a line of defense that will have a chance at success. It is my hope that such unity can be rallied among those who still believe in our basic, inherent, and inalienable rights, freedom, and liberty. Okay, since I'm talking about the 9th and 10th Amendments, let me read the 9th and 10th Amendments for you. For those who, most people at this point who have been listening to me know what they are, but I'm going to go ahead and read them. The 9th Amendment says, "The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people." Okay, the 10th Amendment says, "The powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively or to the people." Okay, so therefore we know then that the content of what's in the 9th and 10th Amendments gives us access to our inherent and inalienable rights. I could make a longer analysis of it. I'm not going to do it. I'm just saying, how are you going to get to your inherent and alienable rights? Now, if I could get the cameraman to go to the board here a minute. When I was talking the last time in the previous teaching on Second Amendment limitations, we spoke about this chart. Now, what we're talking about here is to get around the barrier of the Constitution and get back up to our inherent and inalienable rights. Now, normally speaking, since the 9th and 10th Amendments have not been incorporated onto the states, that causes us a little bit of a problem to be able to apply it. But it could be argued, and it would be valid to say, that the 9th and 10th Amendments are a possible conduit to get around the barrier and get up to these rights. That's important to know. Okay, so, okay, that's enough of that. So there is a constitutional conduit that we possibly could use to get around the barrier and get back up to our inherent and inalienable rights. Unfortunately, the 9th and 10th Amendment have not been incorporated onto the states at this point. So therefore, since that's the case, now you'll remember this article is called the 10th Amendment Center, which means that they're emphasizing the 10th Amendment. They're saying, well, it kind of implies that the 10th Amendment guarantees you certain rights, which in effect it does. It speaks about rights that you have, but as I say, until it is incorporated upon the states, you don't have a legal argument that you can use as if it was incorporated onto the states. You're missing that part. Fortunately, I have been working on another solution which does not depend on having to use the 9th and 10th Amendments directly to get up to your inherent and inalienable rights. Yeah.
The 9th and 10th Amendment, since they're part of the Constitution, they could be used in any federal case, but for the moment cannot be used in any state case. Is that correct?
That's correct, yeah. Okay. That's correct. Yeah, it is applicable to the federal government, yeah, but it's not applicable to the states. Yeah, that's correct. That's a good point. So if the federal government were to pass a law, for example, an anti-gun law, which is an infringement of your Second Amendment rights, you could use the 9th and 10th Amendments there. Absolutely. That is correct. I'm talking about the states, though. And see, in this particular case, like here in Oregon and in Virginia and in other places, mostly you're having to fight against state laws which infringe your right to keep and bear arms. And so you're going to have to deal with the states there.
A minute ago, you used the term Second Amendment rights. I assume you mean that sort of in a specific context.
Yeah. Well, in a sense, do we have a Second Amendment right? Yes. The Second Amendment right is no more than that they shall not violate and infringe your inherent and inalienable rights. Yeah. If you look at it that way, you can say, I don't like to use the term Second Amendment right. Because if I use that term, a lot of people out there in video land, and the people be listening, they said, well, he's saying that the rights of to keep and bear arms and the right to self-protection flows from the Second Amendment. No, it doesn't. It's an inherent and inalienable right. But if you're going to, which happens when you're dealing with law, you're going to split hairs. Yeah, if you're going to split hairs, yes, you do have a Second Amendment right. What is that right? It's the right that your inherent and inalienable rights shall not be infringed. In that sense, you do have a Second Amendment right. But I've trained myself not to use that terminology, Second Amendment right, too much, because unfortunately, a lot of people then think that those rights of right to life, right to self-protection, and by the keeping and bearing of arms flows from the Second Amendment, which it does not.
Or they tend to feel that the Second Amendment is the only way through which they could exercise that inalienable right. Exactly.
Good point. If you're going to talk about the Second Amendment and these sanctuary counties, these pro-gun pro-Second Amendment sanctuary counties, it's about the Second Amendment in that particular case. If you're going to talk about that, then people get a little bit confused in another area, and that is to say, okay, we've got the Second Amendment, and we understand now that it is an inherent and inalienable right. We don't really know how to apply that with legal practices and procedures. We're not sure, but here's what we think. We think, yes, we have those rights. They are inalienable and inherent, but the only way that you can apply those rights is through the conduit of the Second Amendment. That's the problem. It is not true that you can only do it through the conduit of the Second Amendment. As a matter of fact, I've developed a whole legal strategy based on not doing that, based on reaching your right to keep and bear arms and right to self-protection directly, not through the Second Amendment, directly. The Second Amendment means no more than the rights you already had shall not be infringed by the government. It means no more than that. And that is a right. You have a right not to have your inherent and inalienable rights not be infringed. That's correct. But don't get confused about what it all means and how it all works, because then you will indeed start to go down wrong ideas about how to fight anti-gun legislation. What do we do about this anti-government legislation? And I am one of the people who I'm doing everything I can to preserve our inherent and inalienable rights in a peaceful fashion, without having people think that there's no more recourse. We've run out of options. The only thing we can do now is take up arms and use the very arms they're trying to deprive us of to keep our arms. You see, we have to exhaust all of our non-violent remedies. We have to exhaust that. That's our responsibility. We're not a lynch mob that gets all whipped up into a frenzy and starts looking for a rope and somebody to hang from the rope. That's not what we are about. That's not what we should be about. So, let's go on now. Okay, now, let me continue reading. For we are the modern day guardians of liberty. we inherit the burden, duty, and responsibility of liberty and freedom. I state again that we needn't enforce the 10th Amendment itself. We need to enforce the principles of law that the amendment sets forth. See, just because it hasn't been incorporated on the state doesn't mean it doesn't say anything. There are principles of law in the 9th and 10th Amendments that we can use. We just can't use the 9th and 10th Amendments upon the states when it hasn't been incorporated on the states. That we can't do from a legal standpoint. The same is true of the 9th Amendment. In other words, we can reference the message set forth in the 9th and 10th Amendments without actually having direct legal access by way of those amendments had they been incorporated upon the states. Important distinction to know and understand. Such principles are based upon the doctrine that the government rules by consent of the governed, as it is so aptly expressed in the Declaration of Independence. Thus, the people, individually and collectively, hold sovereign status, and this is from the case of Chisholm versus Georgia, 2 U.S. 2 Dol 419, in 1793, in which John Jay wrote that the sovereignty devolved on the people, and they are the sovereigns of the country. Moreover, the people, again both individually and collectively, I'm reading kind of quickly through this, don't miss the part about individually. You don't only have these rights collectively as part of the sovereign people, you also have individual rights, to the right to keep and bear arms and some other inherent and inalienable rights, as I've said in other videos. Moreover, the people, again both individually and collectively, hold inherent and inalienable rights that pre-exist the political system and the federal and state governments. Note very carefully that the people do not hold such rights only in the collective capacity. An individual has the right to access such inherent rights. Otherwise, if that were not the case, then the tyranny of the majority could deprive any individual person of his or her inherent and inalienable rights, thus nullifying the very concept of inalienable rights. Inalienable rights are by their very nature inalienable. If they're alienable, then they're not inalienable, okay? Such rights have also been referred to as the absolute rights of man in Blackstone's commentaries, long studied in relation to legal doctrine. Now, I've talked to you before about the Blackstone's commentaries from Sir William Blackstone, who was a jurist who wrote some commentaries about many issues. Yeah.
It should be noted that you can voluntarily capitulate or acquiesce in alienable rights by actions or omissions or...
Yes. You can voluntarily surrender some of your inherent and inalienable rights by agreement and consent, and also by agreement by performance. And that's important. We're not going to go into that in detail now, but you can do that. You have to be very careful. Can you consent to things? Yes, you can. Do you have the right to consent to things? Yes, you do. Do you have a right to remove your consent? Even if you once consented, can you come back and say, I withdraw my consent? Yes, you can. Very important. Very important. Now, while I'm talking about that, before I continue reading, because these things pop up in my mind while we're making this video. Okay, here's what's going on, so that you understand when you're talking about the Second Amendment and sanctuary counties and sanctuary municipalities. When somebody jumps up and says that thing that they're doing is unconstitutional, and I'm not going to obey that law, or I'm just that I'm not going to comply is one of the things. I'm not going to comply. Yeah, I'm not going to comply. Dig in their heels and say, I'm not going to do that. I'm saying that what they're doing is unconstitutional, and I have the right to stand by the Constitution, and therefore, since it's unconstitutional, I'm not going to do it. And you can't make me do I don't have to do what you say do. You say, well, okay, all right. Here's the problem. Here's the problem. You as an individual, just as a regular individual, have no authority to declare something constitutional or unconstitutional. You can think it's unconstitutional, constitutional. That's okay. If you're an officer, let's say you are a sheriff's deputy, and you say, I took an oath to uphold the Constitution, and they passed a law that violates the Constitution, and they want me to go arrest people because they have a magazine got more than 10 rounds in it, or they want me to seize guns from somebody because the gun looks scary, like an AR-15, scary looking gun. I call it scary looking gun statutes, you see. Let's use the scary looking gun statute. That's a scary looking gun. It's an assault weapon. The look of it is enough to scare everybody half to death. Okay, well, okay. Then the officer says, I'm not going to do it. I'm not going to do it. Well, look, a police officer is not empowered to declare constitutionality or unconstitutionality. Why is that? You may say, wait a second, Pastor Mike, he can do that. He can say it's constitutional, unconstitutional. No, the reason is because he swore an oath to uphold the Constitution. And the Constitution brings in the branches of government. And one of those branches of government is the judiciary. And the judiciary is empowered with the duty and function to declare things constitutional and unconstitutional. Now, you agreed to that. Remember I told you that you have a right to agree to that? You agreed to that. What if you agree to that and you say nothing? Well, that means you're remaining silent on it. That means that the government says, well, you agreed and we have the right to figure that and presume that you're continuing to agree. Therefore, it is frivolous and without merit for you to base your entire act or omission or belief upon the idea that you can declare something constitutional or unconstitutional and that we have to abide by it.
Even though you may be right.
Good point. You may be absolutely right. Unfortunately, I'm here to tell you that being right alone is not enough. I wish it was. I wish we could just all run out being right and do whatever we wanted, you know. I wish it was. I wish it worked like that. It doesn't work like that. When you agreed to something, when you consent to something, because the government operates by the consent of the government. All the jurisdiction that is used upon you comes from you. How is that, Pastor Mike? You agreed to it. You agreed to it. You went out and voted on anti-gun or pro-gun, you voted pro-gun against anti-gun legislation. That's agreement by performance. Now you're saying that your inherent and inalienable right to keep and bear arms can be voted in and out of your life by a vote. You agreed to it. And if you don't object in a timely manner and withdraw that consent, you're frivolous. And you're without merit. And you have no legal standing to do that. Your own actions have stopped you and stopped you because it's an estoppel problem. You've stopped yourself from being able to assert that position by your own actions, by your own agreements. That's what's going on. So when you jump up and say, I'm going to take it upon myself, even though I agreed to have the judiciary handle constitutional versus unconstitutional, I'm going to take it upon myself to declare constitutionality issues. You may be right. You may feel very strongly about it. You may be passionate about it. That's not enough. You have to undo the legal knot that you yourself tied. And I have explained that in some of my other videos. I've said, here's what you got to do. Otherwise, you will be proceeding without proper legal foundation. That's what I'm talking about when I say I developed a different strategy that doesn't depend solely on the Second Amendment. And that's something, I'll be very honest with you. A lot of these 2A groups, when I say 2A, that's Second Amendment, a lot of these 2A groups won't listen to me. They're going to go ahead and proceed with their frivolous, how can I say this without being too mean? With their frivolous strategy that sometimes works. And, boy, do they crow. When their frivolous strategy works and slows down the anti-gun movement, boy, do they crow and say, woo, we saved your rights, we're the ones. Send us more money. We'll hire more attorneys. We'll send out more literature. We'll do whatever. Well, little help it is when now they have established by performance the idea that your inherent and inalienable rights can be voted in or out of your life. You may win. The vote may go towards pro-gun. But if it can go towards pro-gun today, it can go towards anti-gun tomorrow. And then you're going to say, wait a second, I don't like it. I don't like it if the vote goes that way. Well, I'm sure that when somebody goes to a casino and agrees to the gambling scheme that goes on in a casino, when he loses his $5,000, he doesn't like it either, you see. He says, I lost $5,000. I only like to come in here when I win $5,000. Well, it doesn't work that way. It's not real life. In real life, when you walk into a casino and start gambling, you agree to win or lose. Isn't that the way it works?
That's right.
If you find a casino where I always win, let me know, because I'd like to go there. Okay. And then I can complain when I don't win. All right, let's see. Finally, we should remain ever cognizant of the fact that an inherent and inalienable right should not be subjected to a voting process. Exactly what I've been talking about. Where such rights can be voted in or out of an individual's life. It would not be inaccurate to state that such rights exist beyond the encroachment and infringement of a voting process. Exactly right. When the Founding Fathers agreed to what was written in the Second Amendment, where it says, shall not be infringed, that means also shall not be infringed by a voting process. It means that as well. They intended to put some of those inherent and inalienable rights outside the reach of infringement. And you have to start working the problem in your mind. And you're going to say, wait a second, I'm starting to understand how Pastor Mike is putting these concepts together so that we can understand and see them. And of course, that's my job. My job is not to get in front of a camera and say, boy, I'm going to boost my own popularity by sitting in front of a camera. No, that's not what I could care less about my own popularity and fame or whatever, a celebrity. I could care less. My job here is to give you back the key of knowledge. That's my job. Because one of these days, Pastor Mike is not going to be here anymore. I'm 66 years old now. One of these days you're going to read or hear that, well, Pastor Mike got sick and he passed away. And what I'm doing now is I'm depositing truth in your safe so that you can go to your safe and access that truth after I'm gone and say, I know how this works. Because while that guy was alive, he took the trouble to tell me how it works, so that we could understand, so that rights, liberty, and freedom could be preserved. That's why we do this, okay? Let's see, where was I? Every time I do this, I lose my place. Be aware also that you can agree not to access and exercise your own inherent and inalienable rights. We spoke about that. You are not empowered to vote away or nullify such rights belonging to someone else who has not so agreed to give up their rights. Again, let us understand. You can give consent and you can agree to something, but then later on, if you say, wait a second, it wasn't exactly what I thought it was going to be, and now I've done a little more study and learned a little bit more truth, now I want to withdraw my consent. And then the other side may say, you can't withdraw your consent. You see? Well, that's not true. You can withdraw your consent, and you should when it's time to withdraw your consent. Now, you will find out that when you get out on the street and deal with some police officers, they are, bit by bit, I've seen it in different videos, saying, we don't need your consent. That's a dangerous moment. When the officials who carry guns and badges run around saying, we don't need your consent. You see? It all back engineers onto you anyway. We created the government. We endowed the government with sovereignty which comes from the people, and we rely on those people to do the right things with that which we gave them. But when they no longer do that, when they think that they can now function irrespective of the consent and agreement of the people, that's a problem. That's a problem. Now, in some legal nuance, the officer may be right. In other words, if he says, I see in plain view contraband in your car, and you say, well, I don't consent for you to seize that contraband, yes, he doesn't need your consent.
So
it's
it
plain
can
view.
be legitimate.
It can be legitimate, yeah. Yeah. But just the blanket statement, we don't need your consent, that doesn't sit well with me when officers start using that terminology. That doesn't sit well with me. They do operate on the consent of the people. Many today, in or out of government, who would have you believe otherwise, arguing without end that the majority can rule over the inherent and inalienable rights of the individual. That's a problem too. They may argue that without end. I say to you without the slightest hesitation that you are misinformed and have misunderstood the very timeless foundations of fundamental rights, freedom, and liberty, starting at the individual level. It starts at the individual level. Finally, if you disregard such truths, the inevitable result will be that the people will become subject to a government-controlled existence, probably coupled with a police state, okay? Premised on the direct and indirect consent of the majority, or by way of an assumed right of government independent of the people. This assumed right of the government independent of the people. No, the government is always dependent on the people. And if we forget that, then we will end up in a police state and a state-controlled or government-controlled existence, which is something we should work to avoid. That, my friends, presumes to nullify the very concept of the equal status of all humanity, having been created or brought into existence upon equal terms. That's what I said. We were all created and brought into reality upon equal terms, having the same rights. Be aware that governments are populated by such equal status people who, if allowed, will seize the right to dominate others. This is what's also called libido dominandi, the lust of some people to dominate other people. That's what libido dominandi is talking about. Just for the sake of interest, in another place in my own sites, I added the following commentary to the comments I set forth here, as follows. My friends, I tried to share the post itself to my timeline, and you could see it too, but I didn't have the option. To share some of it. I've been having some trouble with Facebook. I can't make it do everything I want it to do. I thought you should see what I wrote so that you would better understand why counties and cities didn't actually have the authority to create Second Amendment sanctuary counties or cities which would override state laws. As I stated, it's a question of sovereign status. Thus, if the state passes gun laws, which we view as unlawful, other remedies must be pursued. Not to say that such actions and statements by counties and cities cannot be effective, for they surely can. Be aware also that even without the authority, states sometimes let counties and cities get away with such actions and sit back to see what happens. even though they know they don't have the sovereign authority to do that. Sometimes they sit back and say, okay, well, let's see how this plays out. All right. In this, we must separate what the law allows and doesn't allow and what happens in reality in spite of the law. I agree that it can become confusing for the average citizen observer. Just for your information, the 3rd, 7th, 9th, and 10th Amendments of the Bill of Rights have not been selectively incorporated upon the states. Parts of the 5th, 6th, and 8th Amendments still remain unincorporated upon the states as well. I will be addressing more on the right of self-protection and the right to keep and bear arms as time goes on. I'll add now that the 1st, 2nd, and 4th Amendments are fully incorporated upon the states. Okay, that ends part 2. Do you have anything that you want to add about part 2? Okay. Let us go on to part 3. How far long have you been in this?
About an hour in.
About an hour in? All right. Let me address part 3 now of the treatise. This is under Code 0108 in 2018. All right. Let me see. Some of this is a repeat of what I already wrote. I'll reread this part. Let's see. Partially in fashion. Okay. Well, I'll go ahead and read it. Okay. Response to deleted. Somebody wrote in a comment, which I responded to. The permission not required. Most gun rights sanctuary counties are anything but. Article is saying in a partially direct and partially indirect fashion that the county ordinance do not actually have the force of law over and above the state law. That's correct, of course. That is based upon the issue of sovereign status, as I explained. They are largely symbolic of the desires of the county authorities who passed the pro-Second Amendment and right to arms ordinances. Okay, as such, they are legally unenforceable as to opposing or overriding state law. Moreover, law enforcement within the county might actually choose not to enforce the state laws that violate the right to keep and bear arms. They might actually opt to do that. However, they do so at some risk of being in non-performance of their duty to uphold state law. The conflict arises as to which oath they will follow. Will it be their oath to uphold the federal constitution, their oath to uphold the state constitution, or their oath to uphold the laws of the state? Now, when I became a police officer, I had to swear an oath to uphold the Constitution and to uphold the Constitution and laws of the state wherein I resided. I had to take an oath to do both. And that is not something that you can just sweep under the rug and say, I didn't do that. It's something you have to pay attention to. So they are sworn not only to uphold the Constitution of the federal government, but sworn to uphold the Constitution of the state and the state laws wherein they reside. That's important. And it has to be worked into your strategy. And, you know, if you're going to formulate a legal strategy, you have to take all of those things into account. They may very well be faced with a glaring conflict of laws which at least some will feel legally unqualified to sort through. I would say that they don't only feel legally unqualified to sort through. I would say that a lot of people are legally unqualified to sort through those. And you need to get some help. That's what I'm trying to do, is help you with that. You need to listen to other legal commentators. There's attorneys out there making videos about legal issues, and it's well worth your time to hear them out. Okay. It is true, however, that an unconstitutional law is itself suspect of a lack of legitimacy and soundness. Well, that's true. It may very well be suspect of a lack of legitimacy and soundness. The question is, as I alluded to before, is who has the power to decide that? Do you as an individual have the power to decide that? I don't mean just for yourself. You can, for instance, if you believe it's something is unconstitutional as a police officer and you say, I'm not going to enforce that, well, you have some options. You can say, I'm going to quit. I didn't sign up for this. I'm going to quit. Or you can stay in your police capacity and just not enforce the law and then be fired. You can go that route. But do you have the right, do you have the power to declare it constitutional or unconstitutional beyond your own beliefs? And the answer is no. Okay. We agreed to have the judiciary do that because we consented to it. But technically, there are legal remedies, practices, and procedures in place to address unconstitutional laws. Yes, there are. Okay. Meanwhile, some police officers may feel justified to go ahead and enforce an unconstitutional law or laws until such a law has been adjudicated to be unconstitutional. Some officers, I've met, talked to some other officers, they said, look, this is legal gobbledygook. I don't know how to work my way through this. If they say the law is constitutional and I can enforce it, I'll just have to enforce it until some court or somebody empowered to say it's not constitutional makes that judgment. And some officers may opt to do that. Okay, so we have to understand that. As to a local law that is aimed at a future state law, it is true that a county may pass such a law, but once the opposing state law is made legally binding, it renders the local opposing ordinance ineffective and legally without force of law to override a state's opposing law. Why is that? We talked about it. Sovereignty. Okay? Most, if not all, county and city ordinances state plainly that they adopt the laws of the state in which the county or city exists. I told you I found that in the ordinances myself. Okay. When a conflict of laws exists in such a situation, the law of the sovereign state prevails. Okay. Now, I didn't make this stuff. This is not me making stuff up. This is stuff that actually occurs out in when you start applying the law in actual application of law and in actual operation of law. Okay. These legal principles are more or less uniform throughout the states. It is not difficult to verify the legal doctrines I set forth in my commentary, articles, and treatises by simply doing a little bit of computer research, because we live in the information age. You can find out a lot just by pushing little buttons on that horrible little box that I have sitting in front of me called a computer. Okay? After all, we live in the age of information. Now, before I go, I want to make something clear and open an avenue of remedial research. When I say remedial research, research to find remedies. Okay? As I already stated, the federal government and the state government hold sovereignty. Back in 1991, I wrote a treatise on inalienable rights, which I now believe I need to update. I do need to update it. I will probably make a video on that too as time goes on. In that treatise, I speak on the doctrine of sovereignty. We need to be aware that while a county or city lacks sovereign status, the people do not lack such sovereign status. Let me read that again because it is extremely important. We need to be aware that while a county and a city lack sovereign status, the people do not lack sovereign status. That was clearly stated by Supreme Court Justice John Jay in Chisholm versus Georgia in 1793. Now, I set forth here what he said in 1793. I'm not going to read it. It's not necessary. I realize that this doctrine requires further explanation, which I cannot go into here or now. But you may already perceive that while a county or city has no power to override state law, the sovereign people do hold such power. I'm going to read that again. I realize that this doctrine requires further explanation, which I cannot go into now, but you may already perceive, and I hope you do, that while a county or a city has no power to override state law, The sovereign people do hold such power. You have to know how to bring those legal issues forward correctly, though. Just knowing that you hold such power without knowing how to bring it, how to use it, isn't going to do much for you. I say again, it is a matter of sovereign status. I am now working on a video presentation effort where I plan to address many different aspects of the subject matter we have been addressing. All right, let me see. Before I end part 3, I will state a maximum that you should consider. I already stated it earlier, but I'll repeat it here, what I wrote. Only sovereignty trumps sovereignty. For those of you who are biblical believers, I will also add, in terms of conceptual thought relative to sovereignty, God is the highest sovereign. See, you can use the people's sovereignty and you can use God's sovereignty if you know how. Okay? Thereafter, God endowed humanity with a lesser form of sovereignty, but still subject to his higher sovereignty. That's for believers, okay? That can be confirmed by scriptural passage that God granted mankind a form or species of dominion, which is jurisdiction. Comes, of course, out of Genesis. Then it is the people, humanity, that created human governments by the consent of the people in order to secure for the people a free state of existence and protect their rights, freedom, and liberty. This is why we created government. I'm going to read it again. Then it is the people, humanity, and this is not just in the United States, this is across the globe, humanity across the globe, that created human governments by the consent of the people in order to secure for the people a free state of existence and to protect their rights, freedom, and liberty. The tendency and lust of mankind to dominate others, called libido dominandi, tries to alter the actual truths, confusing various people in the process by claiming and practicing an absolute species of government authority and control, premised on power and force, which leads to a government-controlled state of existence rather than a free state of existence in which the rights of the people are whatever the government says they are, the laws are whatever the government says they are, and the law means whatever the government says it means. Even when we read for ourselves that it isn't true, sometimes the individual can read, anybody could go to the Second Amendment and read shall not be infringed. And a lot of people, you don't have to have a doctorate degree to understand what shall not be infringed means. So you could read for yourself, and then they're telling you it means something else. It reminds me of a person with a graduate degree who goes through a 2-hour teaching that makes no sense at all to a normal person why water isn't wet. You see? Yes, somebody with a PhD might be able to argue in a way that you'll never understand why water isn't really wet. Okay, well, fine, but to most normal people, we know that water is wet. All right, let's go on. It amounts to a difference between a government granted by the people and opposed to a life of the people granted by the government. There's the difference. There is a difference there, and we should be forever cognizant of that. In the scheme of things, it makes very little difference in terms of libido dominandi what form the government takes, such as a monarchy, democracy, or something else. Okay, I wrote here, I'm not finished, but I wrote here, it has been an honor and a privilege to instruct you in so important in a subject matter. And then I closed it out. Okay, that's the 3 parts. Now, let me talk about, I need to discuss this. We're going to take a break and discuss this part later, after the break. I need to discuss what I've got, this right here. When you start dealing with these issues of sanctuary counties, whether it be on the Second Amendment or whether it be on immigration sanctuary counties or places, you have to understand how to approach some of these issues. Now, I've gone to some trouble to explain it to you so that you know. A long time ago, this is back in let me see, when did I do all this? I don't remember exactly the time period. I believe this is back in 1986 is when I wrote all this. I have a packet here, which is, it's not outdated necessarily, but it is over 30 years old. It's called Jurisdictional Warfare. And this is a fairly thick packet here where it's got legal pleadings in it and stuff like that. See, in 1986, I'd already been at this for a while. And I had some years of jurisdictional practice and procedure under my belt, even in 1986, and that's what this is about. I'm just telling you, this jurisdictional warfare with this conflict of sovereignties that we talk about. These are fairly complex legal issues and strategies to put together, and you have to be careful about thinking that you can just jump up and there are reasons why these, for instance, these sanctuary counties don't hold water. I've taken some trouble to explain that to you. I want you to understand how this all works. And then even once you understand how it works, then you come to the implementation phase. Then you say to yourself, I'm beginning to understand how this stuff fits together, because Pastor Mike has taken the trouble here to explain. But then you come to the implementation phase. And the implementation phase can be complicated. How do I put together the legal pleadings to bring my issues forward? You see, it's kind of like when you send a letter to somebody through the mail. Well, most people do that now by text and email. But in the old days, I'm old enough where we used to actually snail mail. We send snail mail. But if you want to send somebody an idea, when you want to write it down, you need to be articulate enough to write down your idea and then send it to them. The legal system is something akin to that, but much more complicated. You may understand the legal issues that you want to bring forward, but you have to do it the legal way, and it has to be presented in legal form so that you can get your issues in front of them. That's what you have to do. Otherwise, if you can't put the issues in front of them correctly, you have very little chance of being able to, your implementation effort will be hindered and hobbled by your inability to do that. Now, I'm not going to go into all that as part of this particular video. I'm just telling you, jurisdictional warfare. I've been involved in it for a long, long time. I've been in court numerous times on jurisdictional issues, on sovereignty issues. It's a little bit different than what is presented as the practice and procedure in regular jurisprudence, because I'm going outside of that. The reason is because I'm going around the Constitution. Yeah.
The jurisdictional warfare thing, despite its militant title, it sounds like it's exclusively the idea of legal.
Correct.
Legal challenges.
It's good that you brought that up. When I say jurisdictional warfare, I mean that we're going into legal forums and asserting, it's an adversarial forum. A court is an adversarial forum. And we're using legal strategies and pleadings and arguments to make our cases. And that's what I mean by warfare. Yeah. So it is not a violent warfare.
Yeah.
Is that what you want me to clarify?
Yes.
Is there anything else you wanted to say before we take a break? No? Okay, well, when I come back, I'm going to talk about this article itself. For now, we're going to take a break, so I'll see you after the break.